Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Constitutional Law Overview, Powers, Rights, and Review. Let's begin. Constitutional law on the bar exam has two halves, government powers and individual rights. Government powers questions ask who may act: Congress, the President, the courts, or the states. Individual rights questions ask whether government action has violated a protected liberty, equality, speech, religion, or property interest. The MBE tests federal constitutional doctrine. California essays may include federal constitutional claims and California constitutional distinctions, especially free speech, privacy, and state action, but the baseline is federal law. A strong answer begins by identifying the actor. The Constitution generally restrains government, not purely private conduct. Then identify the power or right, the standard of review, and the remedy. Judicial review. Federal courts may declare government action unconstitutional. The Supreme Court has appellate jurisdiction over state court judgments that finally decide federal issues, but it generally does not issue advisory opinions. Justiciability. Article 3 limits federal courts to cases and controversies. The major doctrines are standing, ripeness, mootness, political question, and limits on advisory opinions. Standing. A plaintiff must show injury in fact, causation, and redressability. Injury must be concrete and particularized and actual or imminent. Causation means the injury is fairly traceable to the defendant. Redressability means a favorable court decision is likely to remedy the injury. Ripeness and mootness. Ripeness asks whether the dispute is too early. Mootness asks whether it is too late. Exceptions to mootness include injuries capable of repetition yet evading review, voluntary cessation, and class actions where the named plaintiff's claim becomes moot after certification. Political questions. Federal courts will not decide issues constitutionally committed to another branch or lacking judicially manageable standards, such as some impeachment and foreign affairs disputes. Congress has limited enumerated powers. The most tested are the Commerce Clause, taxing power, spending power, enforcement powers under the Reconstruction Amendments, and power over federal property, bankruptcy, naturalization, patents, and the military. Commerce Clause. Congress may regulate channels of interstate commerce, instrumentalities of interstate commerce, and economic activities that substantially affect interstate commerce. Non-economic activity is harder to aggregate. Congress cannot compel individuals to engage in commerce under the Commerce Clause, though a payment may be sustained as a tax if it functions as one. Taxing and spending. A tax is valid if it raises revenue or reasonably relates to revenue production. Spending conditions must be for the general welfare, stated clearly, related to the federal interest, not independently unconstitutional, and not coercive. Section 5 of the 14th Amendment. Congress may enforce 14th Amendment rights against states through congruent and proportional legislation. It may not redefine the substantive scope of the 14th Amendment. The President enforces federal law, conducts foreign affairs, commands the armed forces, appoints officers with Senate consent where required, and may remove many executive officials. Presidential power is strongest when authorized by Congress, uncertain when Congress is silent, and weakest when contrary to congressional command. Foreign affairs. The President has broad power in diplomacy, recognition, and commander-in-chief functions, but Congress controls declarations of war, funding, and regulation of the military. Treaties require Senate approval. Executive agreements do not require Senate approval, but cannot override valid federal statutes. Separation of powers. Congress may not exercise executive power itself, aggrandize itself at the expense of another branch, or use legislative vetoes. Appointment and removal questions often turn on whether an official is a principal officer, inferior officer, or mere employee. Supremacy. Valid federal law is supreme over conflicting state law. Preemption may be express, field, or conflict preemption. Conflict includes impossibility and obstacle preemption. Dormant Commerce Clause. Even when Congress is silent, states may not discriminate against or unduly burden interstate commerce. Discriminatory laws are usually invalid unless necessary to achieve an important local purpose with no reasonable non-discriminatory alternative. Non-discriminatory burdens are weighed under a balancing test. Privileges and immunities. Article 4 prohibits states from discriminating against citizens of other states regarding fundamental rights or important economic activities unless there is substantial justification. States' sovereign immunity. The 11th Amendment and sovereign immunity doctrine generally bar suits against states in federal court by private parties, subject to exceptions such as consent, valid congressional abrogation under the 14th Amendment, and suits for prospective injunctive relief against state officers. State action. Most constitutional rights require government action. Private conduct counts as state action when a private party performs a traditional exclusive public function, the government significantly encourages or is entangled with the conduct, or there is sufficient nexus. Due process. Procedural due process protects life, liberty, and property from deprivation without adequate procedures. Substantive due process protects certain fundamental rights from government interference. Fundamental rights trigger strict scrutiny. Non-fundamental liberty or economic regulation usually receives rational basis review. Equal protection. Equal protection focuses on classifications. Race, national origin, and alienage classifications by states usually trigger strict scrutiny. Gender and legitimacy trigger intermediate scrutiny. Most other classifications receive rational basis review. First Amendment. Speech analysis turns on whether the regulation is content-based, content-neutral, a prior restraint, vague or overbroad, or directed at unprotected speech. Public forum doctrine determines how much government may regulate speech on public property. Do not apply individual rights doctrine to purely private conduct unless state action exists. Always choose the correct scrutiny level before balancing facts. The Commerce Clause allows regulation of commerce. The Dormant Commerce Clause restricts states. Equal protection is about classifications. Due process is about deprivation of liberty or property. California may provide broader rights than the federal constitution, but MBE answers use federal doctrine. Most questions are solvable by a four-step sequence. Identify government actor, identify power or right, select scrutiny or structural test, and apply the facts. The wrong answer often states a true rule for the wrong doctrine. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.